All right. Good afternoon, everybody. Barry McGuire here. This is another Live at 5, Barry McGuire's Creative Real Estate Education Program. Every Thursday, it's 5 o'clock Mountain Time here at Edmonton. Every Thursday, we talk about things of interest to the real estate investing community. And one of the things that's of great interest to people is asset protection. And that's not what people say to me. They don't say, Barry, we're really interested in asset protection. They go, I probably should have a will. Or they often go, I probably need one of those family trusts. Everybody's talking about family trusts, and I think I need a family trust. So, family trusts are kind of a buzzword. They're kind of a magic word. It's like the word corporation. And in all my years in real estate and in helping the investment community, there isn't one thing that's come up more on the question side of things is the question of a corporation. It's another one of those magic words folks have read, have thought, have talked to other people, and they're pretty sure that they need a corporation to invest in real estate, or they're pretty sure that's a question that needs to be answered before they start investing in real estate. So corporations aren't as important, at least initially, as people think they are, but they're a magic word and it's in people's mind. And so another word or a couple of words that show up for investors when they're thinking about how to protect themselves and what's going on in their investing life is family trusts. Family trusts. And so at this point, I'm going to get Malkit Atwal to join the show. Malkit is in the office. Hey, Malkit, there you are.
Hi, Barry. Thanks for having me. It's nice to be with you again.
Thank you very much. Malkit, folks, in our office that has 3 floors downtown. Malkit, strangely enough, is right next door to me. He and I have offices adjacent to each other, and Malkit is he's an estate specialist. He understands wills and estates and personal directives and enduring powers of attorney up, down, and sideways. He knows about estate planning. Malkit is one of those rare solicitors. Lawyers are divided up into barristers who go to court and solicitors who stay in their office. Malkit is one of those rare solicitors who also is extremely familiar with the courts. So if Uncle Bernie has stolen your mom's estate and is, stripping it bare, Malkit is a guy who can take Uncle Bernie to court and give it to him. And we're not just talking about courts here in Alberta. Malkit has done senior court level work all the way to the Supreme Court of Canada. He advises various groups on their responsibilities regarding their charitable activities and how not to run afoul of the CRA. And so he's an extremely experienced and well-rounded lawyer in all aspects of wills, estates, asset protection, suing, charities, a ton of stuff. So also Malkit is married. He has, I believe, one beautiful daughter. Malkit, you're always, doing school things.
Always running off to either pick her up from school or drop her off at school, or
yes,
yeah, absolutely.
All those responsibilities. So Malkit and I were kicking it around. I told him that that there's a lot of interest in this concept of family trusts, and so he's agreed to come on live at 5 today, and we're going to talk firstly about what a trust is, the basic notion of what is a trust, and then in the realm of what we do as real estate investors and people who have assets and people who have concerns about those assets from a number of different perspectives. Can we protect them? How do we control them? What about our kids? I mean, there's lots of different questions that we have that start to come up as we invest in real estate and as our portfolios increase. It's not as much of an issue when you're young and you don't have any investments, but as you get along in your investing career and you start to accumulate a few properties, and then you accumulate some more, and then there's some equity pay down. All of a sudden you're a going concern, and the notion that something might happen to you, or the notion that you would like to make sure your assets work for you properly, becomes much more of a concern. And so people start looking at, what am I going to do? So Malkit, why don't we just start with having you tell us what is a trust generally, and then let's take it over into what's a family trust from the corporate side, the personal side, and then we'll just let it roll along from there. So let's start with just the basic notion of a trust.
Sure thing. Thank you for the kind introduction there, Barry. One of the biggest myths around trusts is that it's an estate planning vehicle or an estate planning tool only for the ultra wealthy. And that's a very common misconception. When in fact, in reality, a trust or a structure like a trust is something that we routinely do in the estate planning side of things for a variety of clients, regardless of how much money they have. From purely an estate planning view of the world, I look at clients who come to me looking for advice on a variety of issues. They could have a grandchild that they want to leave some money to. It could be as little as $5,000 or a couple $1,000s that they want to make sure that it gets to their grandchild when the grandchild turns 18. And so you're setting up, a little trust for that grandchild in that person's will to make sure that, when that grandchild turns 18, he or she will receive the gift that grandpa or grandma had left for them. You also have individuals who might want to put some parameters around the gift that they want to leave to one of their children or one of their family members in their will. For example, if I have a child who perhaps is going through a divorce or some marital difficulties, and I want to make sure that the gift that I'm leaving to my child doesn't end up getting divided in that matrimonial dispute that my child is involved in, I might want to put some parameters around that gift to make sure that that is protected from any division down the road. Similarly, parents oftentimes, parents of disabled children often are very concerned to make sure that their child that is suffering some sort of a disability is looked after. And so they will appoint a trustee and put money or whatever gift that they want to leave to that child and put it into a trust for the benefit of that child for the rest of their life. So there's lots of uses of a trust in the estate planning world, and we use it routinely. More and more people are getting married, having second marriages and third marriages nowadays. And, an individual who might have children from a first relationship or a second relationship, and who feels an obligation to provide for those children from an earlier relationship, and having competing obligations to a new spouse, perhaps, there's, you can even do spousal trusts for the benefit of your spouse to make sure that your new spouse is protected, but that the ultimate beneficiary of your estate is not going to be somebody that your spouse is going to leave the money to, but it's going to be your children from a previous relationship. So there's tons of ways of using trusts nowadays, and we've been using them routinely for many, many years. And it's a fairly straightforward estate planning tool that everybody should be considering, especially if you have minor children or if you have children that are in a relationship like the one that I described where they might be going through some difficulties, or you have a child who perhaps has other types of problems, addiction issues or gambling issues and those kinds of things. So you want to try and protect your inheritance in a way that allows you to provide a gift for that individual, but also allows you to maintain some control or flexibility of how that gift is going to be handed out to that ultimate beneficiary. The family trust part of this conversation, it's an interesting one. It's because it encompasses a whole variety of different areas of law. It's not just estate planning. That might be the reason that might be driving the creation of a family trust. There's tax components that come into play. There's matrimonial components that come into play. There's obviously lots of corporate issues that are at play whenever you're talking about family trusts. So the types of trusts that I've been talking about where you do this in your will, those are called testamentary trusts. So those are in your will. They come into effect upon your death. The other type of trust that we routinely see in a corporate reorganization type of a file would be what's called An inter vivos trust, and most commonly the type of trust that you're dealing with in an inter vivos trust is a family trust. A trust, as opposed to a corporation, is not a legal entity. So a corporation has its own separate legal identity at law. A trust is a relationship. It's a relationship between the trustee that you've appointed in your trust and the beneficiaries that you've named to receive a benefit from that trust. So it's a relationship, and there's no legal identity separate and apart from the trustee, who becomes the legal owner of all of the assets that are in the trust, but they're a beneficial, or the beneficial owner of that property that's in the trust is the beneficiaries that you've named. It's a very common misconception that a trust is a legal entity, and a trust is a party, and it's in fact it's the trustee of that trust that has control over the assets and is the legal individual who's responsible for administering that trust on behalf of the or for the benefit of the beneficiaries that you've named.
So that's why on the land title side of things, a trust never holds title to property because it's not a legal entity like a person or a corporation.
That's exactly right. And so land titles won't register a trust deed on the title. They won't allow you to register land in the name of the trust. It has to be in the trustee's name, in their capacity as a trustee of whatever family trust it is that you're trying to address. Yeah, that's one of the biggest issues that we deal with. A lot of people are confused by that point, is that that's not a legal entity in and of itself like a corporation, although there are lots of similarities in terms of a trustee's duties that are akin or similar to what a director of a corporation, for example, owes. It's from a legal end of things, it's the trustee that is the one that's responsible for actually having the legal duties and obligations and responsibilities, not the trust itself.
So you started off, Malkit, you said that we're establishing something called inter vivos trusts. What does that mean, inter vivos?
So it's during a person's lifetime. So this is
they're
not
alive.
something that, yeah. So a testamentary trust comes into effect upon your death. An inter vivos trust is a trust that you create during your lifetime for the benefit of whichever beneficiaries you've named. So it's exactly the same. It's there's really no different. However, a family trust or an inter vivos trust that we're talking about usually is related in some way to a corporate structure. An individual has amassed, let's say, a significant level of wealth, and they're trying to do some tax planning and some corporate reorganization to perhaps freeze the shares of a company or the value of a company, and ensure that the children in the family are going to receive the growth, and that the value for tax purposes is going to be frozen at a certain point in time. Those are the kinds of instances where we see family trusts come into effect or come into play a lot. It's not very often where a family trust is created. And I think it has to make sense financially in order for a family trust to be created, because there are some costs associated with obviously setting it up. There's ongoing, we'll get into this, I'm sure, in a little bit more detail. There's ongoing reporting requirements, and the tax is going to be a taxpayer, and there's ongoing tax filings that are needing to be done every year as well. So it is, there are some costs associated with having a trust, and therefore it has to make financially and economically, it has to make sense for the individual when they're
okay. So I want to stop you at that point and just kind of recap here a little bit.
Yeah.
This is like this, for the uninitiated, this is like a fire hose of information, right? They only have just the barest little understanding of what's going on. So to recap, we have testamentary trusts, which show up in a will, and those come into effect on the death of the maker of the will. And we have the inter vivos trusts, which are set up during someone's lifetime, and that's the topic we've moved on to. And where the testamentary trusts as part of a will are a pretty common and very useful planning tool within a will, and don't, it doesn't, because if you say, Malkit, I want a testamentary trust for my 3 kids, that doesn't drive the cost of your will into the stratosphere, because it's a normal planning tool for wills.
Correct.
But when we move over to the inter vivos trusts, now we're more into the realm of what when people say family trusts, I think they're talking more about the inter vivo side, where someone's accumulated a good chunk of wealth at a point in time. And so let's say let's say I'm 50 years old and I now have accumulated through my business or my properties. I've got a $2.5 million chunk of stuff that I've accumulated, and it's growing. I mean, the value, I've done well, and the value continues to grow. And I've got 3 kids, and so what is it that I'm looking to do when I come and talk to you as a guy who's accumulated some wealth, and I've got 3 kids, and I want them to benefit from my wealth. So just what do you say to a guy like that who comes to see you?
Well, it depends, I guess, on what the client's goal is ultimately. If they're trying to, if they're trying to save tax at the end of the day, I'm not sure if the trust structure is the best way to go about doing it. And there are some tax benefits that I can talk about in terms of, capital gains exemptions and those sorts of things that are available to a family trust, which might not be available generally. But generally speaking, CRA over the last several years has come out with a lot of changes to the tax Act, which have removed a lot of the benefits which used to exist for family trusts, which no longer exist today. For example, in the past, I don't want to get too technical in terms of the tax issues here, but what used to happen is a trust would earn income. Let's say there's a $5 million portfolio that's in a trust. It would earn income throughout the year, and a trust would be taxed at the highest marginal tax rate in Canada on that income. Now, in order to alleviate the high tax burden that the trust would be imposed with, what would happen is the trustee would then allocate some of that income by way of dividends to a number of beneficiaries, some of whom could be, children of the family, somebody who was not necessarily involved day to day with the business or in any way with the business, but they would be allocated some form of a dividend from that, from the income from the trust. And the reason you would do that is that the person who's receiving that income or who's allocated that dividend is oftentimes paying tax at a lower tax rate than the trust would be. So it was a way to sprinkle the income out to a number of beneficiaries in order to take advantage of lower tax brackets that the beneficiaries would likely be paying tax at. The CRA in 2018 did away with that rule because it was a loophole that many people obviously used to sprinkle income out of a trust, because the trust would get credit for any income that was allocated to the beneficiaries. The beneficiaries would pay a low tax rate, and therefore there was some tax saving benefits for being able to use that structure. That's now been done away with. The CRA has basically said that in order for you to take advantage of that, the beneficiary that's receiving that dividend has to be involved with the business in some serious way. It can't just be that you're named as the beneficiary of a trust and therefore you're entitled to take advantage of this little tax loophole that existed. So the tax benefits have disappeared in a number of ways over the last couple of years with respect to family trusts. The largest tax benefit that exists today, in my view, and I'm not a tax lawyer and I'm not an accountant, but from my understanding is that if you have shares of a small qualified small business corporation, let's say, and you make a distribution of those shares to a number of beneficiaries, what you can do is you can have this multiplication effect of all of those beneficiaries being able to use their lifetime capital gains exemption. Whereas if only one of those individuals was be able to use it, that exemption might not really have the intended benefit. So there are some benefits, and I think you need to talk to an accountant in terms of whether or not this kind of a structure makes sense for you from a tax perspective. Again, the tax benefits seem to be disappearing, and I think obviously accountants are creative and they can come up with many different ways of structuring these things to avoid having to pay tax if you can avoid it legally. one of the the primary reason why you want to continue to use these structures is for creditor protection, in my view, because it does shelter the assets from the creditors of the beneficiaries of the trustee. There's reasons why you want to continue to use it, but the tax benefits seem to be, in my view, not as beneficial today as they used to be at certain points.
So I heard you say that you have to be working in the business. So if you happen to have a family run business where everybody is actually involved, and they truly are working in by any third party observation, then you can still get those benefits. It's just you can't have layabouts collecting money and not doing any work.
Exactly. And I think the wording in the legislation, I think that the person has to be engaged on a regular, continuous, and substantial basis. So whatever CRA defines those terms as, it's a factual consideration that CRA would do on a case-by-case basis. So I don't know, what level of engagement a person would need to show in order to pass CRA's smell test. But I think, yeah, generally speaking, you can't be somebody who's just sitting back and receiving dividends from a company or from a trust, and you haven't done anything in relation to that business.
All right. So creditor protection seems to be right now the major benefit we would get from setting up a family trust.
Yeah, it's one of the major benefits, and in some jurisdictions, there's also, I think I saw a question coming in earlier on how do you avoid probate. By putting assets into a trust, you're removing those assets out of your estate. So if ultimately you're no longer the owner of that asset, like I said, the legal owner of that asset becomes the trustee of the trust, but they're holding it on, for the benefit of the beneficiaries. So they're a legal owner, but they're not a beneficial owner of that property that's in the trust anymore. So there's this fear, I guess, of people, putting assets into a trust and you're going to lose control over it. However, the trust agreement that you have set out at the very beginning, which kind of creates this relationship that I talked about earlier between a trustee and the beneficiaries, is going to be the document that imposes all sorts of conditions and restrictions and guidelines for the individual that you selected as a trustee of that trust to comply with. So although you lose control legally in the sense that you no longer own that asset, the trust agreement that you are party to will have a number of protections in terms of how the assets of that trust are going to be addressed and dealt with.
So that's obviously really important. If setting up a trust, if I own a bunch of stuff, I've had a bunch of assets, and I am setting up a trust and appointing a trustee who is now going to be in control of all of my assets, it's obviously a critical consideration on who the trustee is.
Absolutely. It's the same when you appoint an attorney under a power of attorney. It's the same consideration that should be given to when you're naming somebody as your executor in your will. It's the individual, ultimately who is going to be responsible for administering your estate, and a trust should form. It's a part of your estate, and if the person that you selected, if you don't have the comfort level and their ability to administer it properly, or to do it in the manner which is going to be fair to all of the beneficiaries that you want to benefit, then of course you're going to run into some problems there in terms of the smooth.
So this is a notion that runs throughout business and relationships, and that is that you can hire the best law firm in the world, i.e. Field Law, to help you with a legal issue, a contract, a something. You can hire us, and we can build paper until it hits the roof. But if the person on the other side is not reliable, then all the paper in the world. I mean, of course, you always need to have good paper, because if things go wrong, you want to have good paper. But that critical first step of picking the right reliable person is very important in this process.
Yeah, and the typical way it works is that a trust. So there are a number of individuals that are involved. So I can give you some definitions or some high level, I guess, concepts in terms of trust law without getting into too much detail about it. But a trust is usually established by an individual known as a settler. So a settler is somebody who's completely neutral, independent. They basically just, settle a trust or start a trust. And then the trustee, so oftentimes in a corporate situation that we're oftentimes dealing with, the settler can be an accountant, the settler can be a parent of the individual, it can be another family member, it can be another professional advisor, somebody to settle the trust. They commence that operation of the trust by putting in the past, it used to be a gold coin. Now it can be a $20 bill. It's something, but after that, they're done with it. Like, they have no further responsibility, and the settler of that trust can never receive any benefit from that trust, or else you are offside a whole bunch of CRA rules, which will create multiple problems for the trust and for the beneficiaries. So the fundamental rule in trust law is that the settler is, once they've settled the trust, they're out of it. They don't do anything with it.
So they start it. The settler starts the trust.
Exactly. And then you have the individual who's a trustee. So let's say, I'm the owner I have shares in a private corporation. I have a spouse and I have 3 children. And I want to make sure, that my interest in that corporation is going to be looked after, and the benefit of those shares is ultimately going to go to my children and to my grandchildren and to my spouse if something happens to me. So there's nothing preventing me from being, as the owner of the shares of that corporation, from being a trustee of my own trust. So that's very, very common. So when I say that you lose control over the ownership of an asset, oftentimes I'm still maintaining control, because what we do is, these are oftentimes very discretionary trusts where the trustee has full discretion to be able to decide how to allocate the income, or how to allocate the capital of that trust, when to pay the money out of the trust, to whom the money is going to be paid. So the trustee / owner of those shares can maintain still quite a significant level of input and control over how the assets of that trust are going to be distributed over a period of time. However, let's say something happens to me in 10 years and I've appointed somebody else to take over my role as a trustee. What it might be my spouse, it might be one of my children, and let's say there's a family disagreement amongst my kids, and they don't all see eye to eye on anything after I'm gone. And you perhaps have created a situation where you're going to have an individual named as a trustee who might not perhaps be as I guess even-handed as you might have been when you were alive. They perhaps might administer the trust in a way that might differ from what you wanted to have done. So it's very important, I guess, in the selection of the trustee to have oversight built into the trust agreement to make sure that that trustee is required to provide an accounting to the beneficiaries for information to be exchanged, because so much of what I do in my estate litigation practice is oftentimes resolved if a person had just provided the information when they were asked for it. And so you want to build in safeguards for not just the trustee to be protecting them from a whole bunch of beneficiaries who might be coming after them, but also the beneficiaries from the trustee walking away with the trust assets, or disposing of trust assets in a way that might be inconsistent with what you wanted to do. The trust deed is a very, very critical piece of all of this, because that's what governs this relationship. So you need to, oftentimes I will reach out to the accountant that's dealing with the client, and we will talk to the bankers and any other professional advisors that might be involved in the deal that we're working on, to make sure that it's all compliant with CRA's rules, the technical rules that we rely on accountants to help us with, and that there's nothing in here that's going to result in an adverse tax event at some point in time as a result of what we're trying to accomplish. Because the last thing you want to do is spend a whole bunch of time and money and energy on creating a structure which ultimately fails as a result of poor drafting or as a result of poor advice. So it's always a team effort, which adds to the cost ultimately, of course, right? When you have accountants and lawyers and all sorts of other professional advisors involved, and you have to have these individuals involved, it obviously adds to the complexity of what you're trying to accomplish, and it adds to the cost ultimately of what you're trying to do. However, these are important things, and again, it has to make sense financially. So if we're looking at a $500,000 portfolio or even $1 million portfolio, maybe spending $10,000-15,000 doesn't make any sense at this point in time, unless it's part of a larger reorganization that you're doing for whatever reason it might be that you want to do it. I would say, it has to make sense financially, because the cost of putting this together, and then the regular maintenance and upkeep of the trust and the regular filings that you have to do, it can be financially more cumbersome than it might be worth, because like I said, the tax benefits of what you're trying to do are really not there anymore, unless you are, unless you're doing it in the way that CRA allows you to take advantage of those tax benefits. And that's where you need some further advice from an accountant to make sure that you're within those rules. A lot of what I do in terms of the estate planning side of things, the testamentary trusts, if your ultimate goal is to ensure that your assets are protected and they go to certain individuals, we can take care of that. There's no need for you, unless there's a significant tax benefit for doing a family trust right now. As part of a larger reorg, there's really no need for you to, put those assets into a trust, unless there's a particular reason why you think that might be necessary in your particular case. Because a lot of times we can deal with it as a testamentary trust. Upon your death, we can take care of the same thing, and the benefits are the exact same typically.
Yeah, Malkit, how does an entity like a Canada Trust or a Royal Trust or Canadian Western Trust, how do they show up in what you do, or do they show up in what you do?
Yeah, quite regularly. So I can. So those entities are professional trustees. Typically, their involvement, it's usually limited to they're acting as executors on estates or personal representatives for individuals. So let's say, I have a client who might not have any family in Canada, yet they have a sizable estate that needs to be administered with a lot of Alberta property. So typically, in the absence of anybody else who is the appropriate person to act as the executor or personal representative, we will reach out on behalf of that client to one of the professional trust companies in town and ask if they would be interested or provide a quote to us for what they would charge in terms of their services for acting as an executor. The other way that trust companies get involved is oftentimes if somebody's named as an executor, a properly drafted will include a provision in there which allows that executor to go and hire an agent to assist them with the administration of the estate. And usually that agent oftentimes is a trust company. So if I get appointed or named as an executor of my dad's will, but I don't have the time to do it, I can continue to act as the executor, but I can hire somebody to do the day-to-day administration of that estate, so that I'm not the one hiring a realtor to sell the house, and I'm not the one running to the bank to open a bank account. It can be done by somebody else. So typically as an agent, they will act. And on even during a person's lifetime, they can act as a trustee for individuals through a court order. The court can appoint a trust company as a trustee during somebody's lifetime if there's nobody else available to represent that individual. And under powers of attorney, they can also represent people as somebody's attorney. So they do get involved, and people have relationships with whatever big bank that they have a relationship with, and oftentimes they'll reach out to that institution, and that bank will put them in touch with their trust department, and oftentimes how that's done.
That I hear about it a lot when someone has taken on the job of being the executor in an estate, and in the middle of it or near the end of it or after, you've heard it a lot, I'm sure, and I hear people say it all the time. Man, I had no idea how much work this was. Yeah. Had I known, I wouldn't have taken it on, or I wouldn't have agreed so readily. And some of them have said, yeah, the only thing that saved me is I went off to Canada Trust or Royal Trust, and I got some help from those professional trustees, because I just couldn't, it was too complicated. It was taking so much time that I needed some help, and they were very happy to have those folks. available, which kind of leads me into another question. So those kinds of companies are Canada-wide, and you and I are here in Alberta. People watching us tonight are really from all over Canada. So maybe you could just give us, a brief idea of whether estate law and family trusts and the way all this operates is the same in all provinces, or if we're in Alberta, but what if you're in Ontario or BC or Nova Scotia? Is it going to be a lot different, or?
Yeah, each province has their own estates legislation. Each province is governed, by their own very specific surrogate rules as well. British Columbia and Ontario, for example, I know, they have property transfer taxes, they have probate taxes, and those are the kind of things that we don't have here in Alberta. So there are definitely differences between the jurisdictions in terms of the manner in which costs and fees are charged by the surrogate courts in terms of estates. And each province, of course, would have their own particular taxes with respect to income and those sorts of things. And so there's always some unique issues that are specific to each province. However, generally speaking, the concepts are very, very similar province to province. There's a trust in Alberta is similar to a trust in British Columbia. There might be some different nuances on a testamentary trust because the fees might be a little bit different because there's taxes charged on the overall value of an estate, whereas we don't have those kinds of fees here in Alberta. So there's some nuances, but the overall, the concepts are very similar across the country.
Okay. All right. Well, I mean, that's pretty good overview of trusts on the testamentary side and on the inter vivos family trust side of things. That's a pretty good summary. I'm sure we've spun people's heads this way and that way. Let's look at some of the questions. I don't want to get ourselves to 6 o'clock and find we haven't answered any questions. So let's look at a few questions right now and see what people are saying. So I'm reading this first one. Facebook user, what are the best ways to bypass probate other than the traditional ways of spousal transfer, beneficiary, etc.? And I don't know if you want to ask a guy whose life is all about doing wills how to avoid probate, because I see what Malkit says, but I think that's kind of another one of those myths that you're better off if you can keep stuff out of probate, and lots of people think hard about doing that. But Malkit, what do you think? Should people be trying to bypass probate?
I mean, this is a common misconception. I give a lot of these kinds of talks to financial institutions and individuals. This is a question that always comes up. So it's not a surprise that this question gets raised in this forum as well, Barry. But in jurisdictions such as British Columbia and Ontario, where there are probate fees and there's estate taxes and those kinds of issues that are perhaps that beneficiaries or executors might be concerned about, or individuals might be concerned about, we don't, we're fortunate in Alberta here that we don't have those kinds of similar concerns. I know in Ontario, they've developed, a whole bunch of different ways lawyers have. They have multiple wills that they will draft, for assets that are going to be probatable and assets that are not going to be probatable. We don't have those kinds of issues here in Alberta. So I can't speak to other jurisdictions in terms of what lawyers will do to try and avoid probate. But my advice in Alberta to my clients who are concerned about probate is that this is not something to be fearful of. Probate it's one of those things that people are concerned about, that their estate's going to be held up for a long period of time, and they're not going to be able to administer the estate in a timely way, or it's going to cost a lot of money. In Alberta, we're fortunate we don't have those kind of concerns. So I always tell people, in fact, I would say there's probably 4 files that I'm working on these days on the litigation side of things, which resulted from people transferring assets into joint names and designating beneficiaries when they really didn't intend for that individual that they were naming as a joint owner, for example, of a property, to really be the owner of that property, but to share it amongst a whole bunch of other individuals. So if you're doing things like putting assets into joint names to try to avoid having to pay $200 to the Alberta courts to issue a document which authorizes your executor to do what you've told them to do, you are potentially creating significantly more problems legally for yourself and for your estate. One of the issues that people don't realize, and this happens all the time, where we have a parent, for example, or an elderly parent, who will go and put their son or their daughter as a joint owner of a house or a bank account. And there might be 2 or 3 other kids in the family who are also just as equally entitled to mom or dad's estate as the one that you've named as a joint owner. And oftentimes that's done for the ease of, helping mom or dad pay their bills, helping them, make sure that they're getting the tax notices from the county or from the city so that everything is up, everything is being done properly. It's not generally done with the intent of gifting that asset to that child. The presumption at law when somebody gifts or names an adult child as a joint owner of a property, the presumption at law is that that child is holding it on trust for the benefit of your estate. And unless that child can prove that you intended to gift that asset to them, that presumption is that all the beneficiaries that are out there in your estate are equally entitled to a share of that asset. A lot of people don't realize that presumption exists and will go ahead and transfer an asset into the joint name. And what it does is just muddies ownership issues, and it creates just so much conflict between families because once mom or dad's passed away, that child who's been now named as the joint owner of that asset often will forget that it was supposed to be shared with the rest of the family and it wasn't just supposed to be a gift to them. Money does funny things to people, and so I see a lot of litigation coming out of joint ownership of assets, which I try to talk my clients out of. And if you're going to do it, you just have to paper it really carefully to show what you intend to do, or what your intent was when you put that person's name on, because otherwise there's a big question mark as to why you did what you were doing. So it's in Ontario, BC, maybe there's reasons why you would consider doing some things to try and avoid probate, because there are some costs savings perhaps that arise from doing so. And I'm assuming lawyers in those jurisdictions are taking the proper precautions to note their files and make sure that everything is papered properly, so your intent when you're doing those things is properly reflected at the end of the day. In Alberta, we're fortunate we don't have those kind of concerns. So if we can avoid putting things into joint ownership, which you have no need to do if you have a properly set of estate planning documents in place, you really have no need to be adding anybody to the title of your property or the name them on the bank account with you. It's unnecessary here.
So folks, I want you to listen. Just run that round in your head a few times. What Malkit said. Over my lengthy career as a lawyer, I have run into not endless numbers, but many broken family situations that have blown up over the estate. So, and this doesn't even take into account someone who has transferred a property into joint names because they think they want to avoid some probate costs. It's just, as Malkit said, money makes people do funny things. And so when people are doing funny things anyway, adding another layer of transferring properties around and not knowing what you're doing and not understanding the presumptions and not allowing for how money makes people do funny things, all that does is make what maybe is already a bad situation even worse. So ultra important on the anything involved in this area, in the wills area, the family trust area, to get good, solid professional help. And you got to spend some money to get the job done right. It doesn't matter whether it's law or getting your car fixed or going to see the dentist. You need a really professional, competent person assisting you with what are very important decisions. So, having said that, next question. What does Justin say? Trusts bypass probate, I think Justin means, and creditors. That's Justin, you're a man of few words. Malkit, what do you think of Justin's question?
I think if I understand Justin's question is, by putting assets into a trust, can you avoid probate? Yes. That is one of the reasons why you would, and I know we talked about this earlier, definitely by putting things into a trust or assets into a trust, you're no longer the owner of it. Therefore, it no longer forms part of your estate. And therefore, it's not an asset that you own, an asset that you can give away. So yeah, there's no need to probate anything that's in a trust. One of the things that I think, might be important, I guess, worth mentioning is probate applications are public record. They get put on the court file, and anybody has access to them. If you want to pay a fee and obtain a copy of that file, that's all public record. Trusts, however, those are private, confidential documents as between the trustee and the beneficiaries. So there's no, you don't file those documents with the court. They're not registered on land titles. They're not usually available to anybody other than the individuals who might be involved in that trust. So there is some privacy protection there, as well as creditor protection, which is what I think Justin's second question was in respect of creditors. Is this creditor protected? Is this a means of protecting assets from creditors? And the answer is yes. If the beneficiaries, for example, have a number of creditors that are chasing them for whatever they're chasing them for, the beneficiaries don't own the assets of that trust, so the creditors can never go after the trust assets. Any income that you give to the beneficiary from that trust, of course, the creditors can pursue that, but the capital of the trust is protected from creditors. Yes.
So that kind of ties into Carlene's question, where she says, can you please elaborate how trusts can offer creditor protection? So you kind of just said that, Malkit, but maybe you can just elaborate or say it again.
Yeah. So let's talk about a matrimonial divorce situation, for example, where let's say I'm the trustee of the trust, I'm the owner of a corporation, and I'm the trustee of the family trust, and two of my sons are named as beneficiary. My wife is named as a beneficiary, but one of my children is going through a really ugly divorce, and I want to make sure that whatever is available in the trust for the benefit of my child does not end up getting divided in his divorce. So what I would basically, at that point in time, if I'm the lawyer for the spouse of my child, I would be obviously inquiring as to what interest my son has in that trust. But legally speaking, my son doesn't own any thing in that trust. It's a fully discretionary trust. I, as a trustee, am the one making decisions as to when or if my son receives anything from that trust. And therefore, even though my son's spouse might be able to say, well, he's going to be entitled to receive something from this, and therefore I should be entitled to more of the assets in my marriage, it's very, very difficult argument to make. From a matrimonial perspective, it's great protection if you have an individual. Those assets just don't get divided unless I pay out income to my child every year on January 1. Then of course that forms part of their income, and that can lead to a whole bunch of issues in terms of spousal support obligations and child support obligations. But that's a totally separate issue than the one we're talking about. The beneficiaries of the trust are the beneficial owners of the asset, but they're not the legal owners of the assets in the trust, right? So the creditor does not have any recourse as against those assets in being able to pursue any debts that might be owed to them until that money is taken out of the trust and paid to that beneficiary, and then it's in their bank account or in their name.
Okay. Yeah. The beneficiaries don't own anything, do they? And the trustee is, in a discretionary trust, it's up to him.
That's
so
right.
Yeah, there's a nice layer of protection there that's very difficult to get through. Justin's back with another question. When a property is owned by a couple / individuals in joint tenancy, it looks like, can a trust be jointly set up? Good one, Justin.
Yeah, you can have joint trustees. You can have more than one trustee. Yeah, so there's no concerns about having more than one trustee be named as trustee of the trust. I'm trying to understand why in this particular, as joint owners of a property, why you would, if there's anything that would prevent you from being trustees of that trust jointly. And I don't think, I can't think of a reason why that would not be workable at law. Like I'm failing to see any sort of a problem with that at all, Barry. Like I don't think that would be an issue. I've done lots of trusts where we've had, spouses acting as joint trustees of the trust, or upon the death of one spouse, the other spouse would step into their shoes as a trustee, and oftentimes that's very it's quite normal.
Okay, thanks for that, Malkit. Sarah says, what if you have international real estate in your portfolio? Does that complicate your will? Well, Sarah, anything international is going to complicate life for sure, but let's talk about real estate and the will. What do you think, Malkit?
I think, depending on which jurisdiction that asset is held in, you might be treading on some dangerous territory with CRA in terms of where the trust is actually located. Oftentimes, if the trustee is a Canadian trustee and they're a Canadian citizen, or if the trust is being administered from Canada, I think legitimately you would have the argument that it's a Canadian-based trust. There's no a lot of families, that own property in the U.S., for example, they will hold the property that they've bought in Arizona or wherever in a trust structure. So it is very, very common, but oftentimes it's not something that I would normally draft for a client here. I would ask to make sure that I'm complying with the jurisdictional laws of that state or that country. I would be reluctant to, advise any client in Alberta on the laws of another jurisdiction without having some consultation or discussions with counsel in that foreign jurisdiction before we ever did something like that here. But it's obviously it's something that people do. It's very common with respect to American properties that snowbirds own, and oftentimes there is a reason why people are trying to do it that way because of the estate tax in the United States is much more onerous than it is in Canada. There is an estate tax that's imposed in the US, so there's multiple reasons why you might want to consider some sort of a trust structure when you're purchasing property in the United States to avoid having to deal with it as part of your estate after you've passed away. So it is possible. It just does it adds a whole bunch of complexity simply because there's going to be more people involved in preparing this document and making sure that you have advice from the right individuals.
So you might have you might have a set of lawyers and accountants and professional advisors in one jurisdiction and require another team at that same, fairly large expense of professional advisors in a different jurisdiction. So yes, indeed, it raises complication, but you need that advice. If you're going to be owning property in other jurisdictions and you live in Alberta, you have to delve into what that means for you here and what it means for you down there, and how the two jurisdictions meld, and the rules are different in different jurisdictions. So yes, Sarah, lots more complicated is the answer.
Facebook we're fortunate. We're fortunate. We have in-house here. I mean, we have a good tax team in our Calgary office as well. As I think one or two lawyers that are called to the bar in the United States. I think one in Florida and I think one in Arizona, if I recall correctly. So there is some in-house expertise that we can kind of rely on here when we do have issues dealing with the United States. Foreign ownership of properties in Mexico and in Europe, I think you would be looking at a much higher expense simply because you would be dealing with counsel in another country where we don't get to control what they would be charging on that.
All right. Well, we're getting close to 6 o'clock, Malkit, and I have another webinar on after this one. And so before we get to the end of this, I'm just going back to the beginning where I said what we've done is dive into the middle of asset protection and wills and that whole much bigger question. We dove in the middle because people wanted to know about family trusts. But what I think might be really valuable is to kind of go back to the beginning, and somewhere along the line, we'll do another. This is a field trip, folks. Get it? I'm at field law. Malkit's at field law. We're doing a field trip. Everybody loves a field trip. We'll come back another time and do another field trip where we're going to go back to the beginning and talk about wills and personal directives and enduring powers of attorney, which is kind of the three-part package. Because in my mind, not a wills guy, but in my mind, I'm thinking that all of us should have a will and probably those other two things set up. I mean, am I off base when I say that, Malkit, or is that really something that most folks should have in place?
Absolutely. If anything we've learned from this year is that life can change pretty drastically for all of us without too much warning. So it's definitely something that everybody should be contemplating having, and it doesn't have to be complicated. It's something that you can definitely seek some advice on, and it's very important, not just for yourself, but for the people that you're leaving behind potentially.
Yes.
Your children and your other family members who are going to be dealing with your affairs if you're no longer around. So yeah, absolutely. It's all three of those documents are absolutely critical.
Okay, well, we will come back, and instead of being in the middle, we'll start at the beginning for the next go round. Let's take a look and see, are there any more questions? We've probably got time for another one or two. Facebook user says, hopefully you can respond to my question. Thank you. Are you the only Facebook user?
Is there any advantage?
No, I don't see it. Where is it? DC. Okay, here it is. Sorry, didn't see that. Now we got it on screen. Is there any disadvantage of setting up the inter vivos family trust when you're starting versus down the road once you've accumulated significant assets? So, okay, Malkit. I think I know the answer, but you say.
The biggest disadvantage would be the costs. The initial setup costs, the tax advice, the legal advice, the drafting of the trust agreement, I think would be a deterrent, I think, for a lot of people, because it's not going to be cheap to set that up. And then there's ongoing filing obligations with CRA every year from that point forward, because the trust, as the structure that you put in, it has reporting requirements, pretty strict reporting requirements to CRA. And filing requirements with CRA every year. So the cost, I think, alone would be a deterrent. In terms of any other disadvantages, and to me, it has to make sense financially and economically for you to kind of endeavor down this road. And I don't know necessarily what sort of assets this user might be referring to in terms of what they would be considering putting into the trust. But once you put something into a trust, if it's not worded very carefully and if it's not structured very carefully, you simply don't want to end up in a worse, having created a structure which is going to be difficult to untangle if you decide down the road that it's not something that makes sense. So
all right, so that's you gotta really have some assets, got to be worth some money. You got to sit down with your pros and say, okay, here's the asset picture, here's what we're trying to do. What are you professionals going to, end up charging me? And then you got to match it up and see if it's going to make some sense. See if the benefit is going to be there for the money you're going to spend. Yeah. And that brings us to 6 o'clock. Well, I guess we can't cover the whole world of wills, estates, and family trusts in 1 hour, Malkit, but certainly a good effort. Thank you very much for showing up and helping out here. I thought you made some complicated topics fairly easy to understand, and we will definitely have you come back at another time, and we'll do another session right at the beginning when we talk about wills and enduring powers of attorney and personal directives, which will, I think, get a lot of people started in the right direction. So thank you very much. We're going to sign off now and get ready.
Have a good next podcast there.
Okay, Malkit. Well, we'll see you tomorrow.
Thanks.
Okay. Bye-bye.
Bye-bye.